Again, counsel, we have reserved 15 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
Your Honor, if I could reserve 5 minutes.
So noted, Madam Clerk. You may proceed, counsel.
Good afternoon, Your Honors. I'm used to saying good morning because this is the first time I've had oral argument in the afternoon. I want to thank you. My name is Chad Barr. I represent the appellant in this case, Haygood and Gifford LLC. Excuse me, I'm battling some allergies here. I want to take an opportunity to thank you for having me up here. It's the first time I've argued before this court, and you have a beautiful building, and I appreciate the opportunity to be here. We're seeking in this appeal that this court reverse the trial court's finding in favor of the Bentleys that there was no constructive notice of a prior recorded mortgage in the official records. I know Your Honors are familiar with the facts. If I could just point out some brief highlights, kind of the ESPN version of the facts of this case, and I'd like to start from the end. On December 30th, 2013, the appellees purchased, or they filed in the official records, a warranty deed with respect to the subject property. At the time they filed their warranty deed, there existed in the records a mortgage that defendant Needles, Michael Needles, executed in favor of Haygood and Gifford, and there also was a quitclaim deed from defendant Needles to Peterson Managed Investments. And Peterson Managed Investments is the company that deeded the property in a warranty deed to the Bentleys. So at the time the Bentleys recorded their warranty deed, there was a quitclaim deed and there was a mortgage in the record. I've battled with this case a little bit. I don't do a lot of real estate law, so this was taking me back to law school for sure. But I've battled on the issue, and I've taken it from a very complex issue to a very simple issue. But I think when we boil this case down, it really is a very simple issue. And the issue is, does the fact that a mortgage is not recorded while the guarantor, or the grantor, has possession of the property, defeat notice altogether? That's what the trial court found in this case. The trial court found that because the mortgage from Needles to Gifford and Haygood was not recorded while Mr. Needles owned the property, it was executed while he owned the property, but because it wasn't recorded, that there was no notice whatsoever for the appellees in this case. What the trial court did when it issued that ruling is it completely disregarded all the elements of notice. It disregarded express notice, it disregarded actual implied notice.
Well, the only issue here is constructive notice, right?
I don't necessarily agree with that.
You didn't argue below on actual notice, did you?
I think that it's all encompassing. It wasn't our motion, it was the appellee's motion for summary judgment, and I think that just because the court found there was no constructive notice doesn't mean that was entitled the appellees to a final judgment, because the court made no finding as to implied notice, implied actual notice, which is what the record... That
wasn't litigated below. What was litigated below was constructive notice, right?
Constructive notice was...
The issue in this case is whether or not, the facts are not in dispute, essentially, whether or not your client's late, I call it a late filed recording. I only mean that in the sense of it was recorded about a year and a half after the mortgage was issued. But it was recorded before the appellees recorded their, I guess, their mortgage.
It was a warranty deed, yeah.
Warranty deed, excuse me. So you have a $30,000 mortgage that you filed before they filed their warranty deed, which, as I recall, is the values are about $280 on the deed. Or this a residence and a home?
I honestly don't know what's happened with the actual land.
So that's the issue. The search does not reveal, by looking at a grantor-grantee examination, your mortgage deed. Your argument is that your obligation under state law is to search by tract, by different measures, because you did what you were required to do by law, right?
Yeah, that's basically what it comes down to.
I don't think you preserved any argument below. I saw your briefs. I saw the discussion of the gentleman saying I owe him $30,000 and I'm not going to pay him. That wasn't litigated, right?
I believe it was. I believe that it was well, and the reason why I'm saying that's because it was filed in response to the summary judgment. It was in an affidavit filed in response to the summary judgment, specifically stated evidence in response to the summary judgment. I think the point on the actual...
Let me ask you, what relief is it you're seeking?
What we're asking the court to do is reverse the trial court's finding that there was no constructive notice and send this case back down and have the
There's no
final...
reason to send it back down. If we rule as a matter of law they have constructive notice, you win, right?
I agree with that. And if the court is so inclined to remand with instructions to enter judgment on that or enter a finding on that issue, then
We don't issue findings. We decide as a matter of law, does your recording beat, or was it earlier in time? Were they put on constructive notice? That's the issue.
I agree.
I see it.
And that's fine. And let's talk about that. What we've got is a record full of cases that do not support the trial court's finding. If we look at each and every case that the trial court relied on, if we look at each case that the appellees relied on in their brief, none of them are on point with the facts that we have in this case. What we have to look at is the notice statute, which is 695.11. All it requires is that a conveyance, instrument, mortgage, deed be recorded in order to provide notice. This court's found in several occasions, in several cases, that simply filing a document is sufficient to convey notice to a subsequent purchasing party. So in this particular case, what we have is a situation where the deed was, or the mortgage was recorded before they purchased the property and executed their warranty deed. We don't really have to go any farther. There's no interpretation of the statutes. There's no anything beyond the express language of 695.11. What I failed to see in any of the pleadings, any of the briefs, is an express requirement that requires that the mortgage, in this case, be filed during the time period in which Mr. Needles owned the property. They can't argue that it's a wild instrument because it was executed at the time Mr. Needles owned the property. So we don't have that issue. They've not identified any case that says that supports their position. There's no statute that supports their position. And this court has held on multiple occasions that it's not going to read requirements into the recording statute that are not already there.
Counsel, with the record before this court, could the court find, based on the record before this court, that the Bentleys had actual notice of the mortgage at the time they recorded it?
I think that the court could find that they had actual implied notice, but you know, as Justice.
But the point was, did you argue that point below?
And I think that's the point that I'm trying to make, and I apologize, I'm not making it very clearly. But even if the court found that there was no constructive notice, it wasn't sufficient for the court to enter a final judgment. The court could have said, because there's three types of notice, the court could have said there's no constructive notice, but there are still the issues of implied actual notice or express actual notice. And that's what the arguments are in my brief, is that the court could have found that there was no constructive notice, but that still doesn't eliminate the issue. Because in this case, if we look at the record, we see that we have a quitclaim deed, which should have piqued somebody's interest in the first place, and we also have a mortgage recorded from the exact person that issued the quitclaim deed to PMI. So I think that in keeping with Justice Thomas, I don't think that this court can necessarily find that there was implied actual notice. I think the court can remand with instructions to determine, or for the trial court to make a finding that there was, whether or not there was implied actual notice. And I think that's...
Did you argue implied actual notice in the proceedings below? That's the question.
You filed an affidavit, right?
There was an affidavit filed by Mr. Needles who said that there was...
He told the realtor that I said I owe him $30,000 and I'm not going to pay.
Correct. So that
Is your position that created a question of material fact to defeat the motion for summary judgment?
I think that, coupled with the fact that there was a quitclaim deed, and this court has specifically held that if there's anything in the record that require you to go look somewhere else, then it's a negligent omission. And that's exactly what we're talking about here. There was a quitclaim deed, there was a recorded mortgage, and there was information provided to the realtor who was selling this or closing this property that there was money owed on the property, and that that PMI intended to not satisfy the mortgage that was, or the money that was owed on the property. So I think that even if the trial court was correct that there was no constructive notice, that didn't satisfy the question of, is there implied actual notice? And it wasn't asserted in a motion, but it's a question that still exists in this case. And the trial court can't eliminate that issue just by simply saying that because the mortgage wasn't filed while Mr. Needles owned the property, that all notice is absolutely eliminated as a matter of law. And I think that's why the argument was raised in our brief that it's not a done deal even if the trial court's correct. Of course, we don't believe the trial court was correct because there's no case law to support the finding that it made in this case. What I'd like to do is, I know that appellee is going to argue some cases. I want to reserve my remaining time to address some of the cases that they intend to argue. If there's not any other questions, I'll turn it over to the appellee. Thank you.
Thank you, counsel. You may proceed, counsel.
Thank you, Your Honor, my name is Steve Traylor. I'm with the firm of Borowski and Traylor. We have the pleasure of representing appellees in this matter, Mr. and Mrs. Bentley. Your Honor, may it please the court, I'd like to clarify something that appellant's counsel said. He said this boils down to the issue of whether a mortgage that wasn't recorded during the time Needles owned the property gives notice. I'd like to clarify that. There's a term for that in the law. We call that an instrument that's recorded outside the chain of title. Case after case uses that terminology. The chain of title is formed by the links at the time during which a person owned the property. A link in that chain strings together back to the sovereign, form the chain of title to the property. When an instrument is not recorded in the chain of title, it wasn't recorded during the time that the owner of the property was the owner of record. That's exactly what happened here. The mortgage that Mr. Needles granted to the appellant was not recorded during the time in which he owned the property. Therefore, cases tell us it was recorded outside the chain of title. What cases, more importantly, tell us is that no constructive notice can arise from what's recorded outside the chain of title. And that makes sense in Florida, where we have a grantor-grantee indexing system. We look at that index, we see when a party owned the property, we search the record during that link in the chain of title. The alternative to that is to start at book 1, page 1, and turn every page in what amounts to hundreds of thousands, if not millions, of pages of documents.
Is that system computerized?
Your Honor, I believe most counties, that system is computerized.
Was it computerized in this county?
Your Honor, this property is in Santa Rosa County. The online system that the public sees is computerized. You can search that way.
By tract?
Pardon?
Can you search by tract?
You search by the owner's name, or if you know a particular booking page, you can search by the booking page number as well, Your Honor. It is my understanding of, based on my usage of that system. Your Honors, Section 695.01 is what is referred to as the bona fide purchaser for value statute. The substance of subsection 1 has been in its present form in one statute number or another since 1828, 17 years before statehood. John Quincy Adams occupied the White House when that statute became law in the state of Florida. A lot of cases have been decided since then. One of the appellant's argument in their briefs is that the trial court was wrong to read any requirement into that statute that an instrument be recorded in the chain of title. The statute does not explain a lot of things that cases parse out. For example, the statute doesn't expressly say that an instrument must be recorded in the county where the property lies. The statute does not expressly state what requisite formalities are required, or the form of the acknowledgement, or whether the instrument contains a legal description. We look elsewhere for other law, other cases that parse out those issues. The statute doesn't define or explain notice. The cases parse out constructive notice, and that's what this case is really about. The Needles did, in fact, or the Bentleys, excuse me, did in fact both file affidavits in support of the summary judgment. They're attached as exhibits in the record to that motion that both unequivocally state that they did not have notice of this mortgage. So,
Could you distinguish the Mayfield case for us? I mean, if you look at the Mayfield case, the flawed document there was improperly filed by the clerk. So in that case, that would have been outside the chain of title, correct?
Your Honor, my law partner and I had the pleasure of representing the Mayfields at trial and before this court, and I recollect that you were on that panel. But that case did not actually involve an instrument outside of the chain of title. It involved cases or instruments that were recorded in the chain of title, but then voided about 73 minutes later. And the issue was whether those documents that were there but are no longer there give constructive notice. So here,
Well, and I want to clarify the question. You know, once they were deleted, they did not appear in the chain of title, correct?
That's correct. They did not appear in the public record at all in the chain of title or otherwise once they were voided.
And the rule there certainly was, once recorded, it was constructive notice to all, you know, future purchasers. So, you know, how do we distinguish that case under the facts here?
Your Honor, that case is distinguished by all the cases that clearly say constructive notice only arises from what's in the chain of title. And this is an old doctrine that goes back over 100 years. In fact, one of the cases cited in our brief is the case of Manfield versus Johnson. It's at 40 Southern 196. It's a 1906 Supreme Court case. And in that particular case, and was otherwise a factually complicated case, but what it really boiled down to is Mr. Johnson, the plaintiff, held a judgment on a piece of property, and he was also the purchaser of the property at the sheriff's execution sale on that judgment. There was a prior recorded instrument, a recorded deed in the chain of title that on its face indicated that other people had an interest in this property. But the issue with that particular instrument was that it was not recorded in the chain of title of the property. And what the court said in speaking of this instrument, there was therefore nothing in these documents to put Johnson on notice. As to the deeds from Cayley to McCowan, neither Drew nor Johnson were parties thereto, nor was it a link in the chain of title to Drew, through whom Johnson claims. The court went on to find that Mr. Johnson was in fact a bona fide purchaser, and said he cannot be bound thereby in the absence of actual notice, merely because the deed was recorded. In short, it was recorded. It was recorded prior to Mr. Johnson's judgment interest. But in short, it was recorded outside of the chain of title. In fact, in the appellant's brief, the appellant speaks to the issue of a title examination. On 25 of the initial brief, the appellant explains a title examination, and there's a block quote from a Florida Bar Journal article. I'm reading at the bottom of page 25. A purchaser frequently employs the services of attorneys or title search companies to review the chain of title to a particular piece of property. That's what a title examination searches. Not the whole public record from book 1, page 1, up to the present, but what's in the public records in the chain of title. And the Florida Supreme Court spoke to that very issue in the 1939 case of Pearson v. Bill, that's at 189 Southern 679. And in speaking of a title insurance policy, the court writes, a title policy is not extracted from pure guess or speculation. It goes on to say it contemplates a search of the chain of title.
And counsel, understanding we don't have facts in the record to establish whether the Santa Rosa system was searchable by tract number and parcel number, but hypothetically speaking, if there were a system that were searchable by grantee, grantor, grantor, grantee, and by the parcel number, would that make any difference in terms of whether something should or should not be recorded outside the chain of title to be effective notice?
I suppose if that hypothetical system allowed you to search every instrument relating to that parcel of property, and narrowed it just to that parcel of property, then that would be a different analysis. But here with a grantor-grantee indexing system that
I'm curious, what exactly, excuse this fundamental question, what exactly did the appellant's client have to do to record this mortgage inside the chain of title?
all it had to do was record its mortgage timely, Your Honor, and not over a year later after Mr. Needles no longer owned the property. It was really just that simple, and I submit that experience demonstrates that a prudent mortgagee records his mortgage promptly and doesn't wait over a year plus before doing that, because as 69501 says that instrument is not good and effectual against creditors or subsequent purchasers for value unless it's recorded according to law. And recording it promptly is one of the ways.
The legislature has never said, I mean, you make an interesting argument, and I love history, so I love hearing about decisions from 1906 and who was in the White House in 1820, was it 8 or 4?
In 1828.
1828, I mean, I love history. But the flip side of that argument is in all those years, the legislature has never used the phrase chain of title in the statute.
Your Honor,
I mean, they very well could say, look, you have to file according to the clerk's office, and I guess you won in the Mayfield case.
No, sir, the Mayfields actually lost that case.
Oh, you lost that case?
Yes.
Well, I mean, if you file according to law, then why didn't the legislature just say, and within the chain of title in the statute?
Your Honor, subsection 1 of that statute has been in its present form, almost perhaps word for word, or certainly near word for word, since it's.
I guess your flip side argument to that would be the Supreme Court has talked about chain of title, and the legislature's never,
Your Honor,
never rejected that interpretation. So I guess it cuts both.
Yes, sir, and there is case after case. In fact, beginning on page 12 of the appellee's answer brief, we have a long string cite that cites cases from the Supreme Court in every single DCA that in one context or another state very clearly that what gives constructive notice must arise from an instrument recorded in the chain of title, and not just based on the fact that it's merely recorded somewhere among the voluminous.
It's pretty amazing this question's really never been answered, where you simply have a late filed recording. In your case that you did not prevail in, the clerk deleted the recording.
Well,
And so we essentially held, as I recall, that you had a cause of action possibly against the clerk, but it was not recorded because it was deleted. Whereas here, you simply have a late filed mortgage. So that kind of imposes a time requirement too on recordation, right?
Your Honor, it's certainly a prudent purchaser of property or mortgagee records his instrument timely, because it fails to do that at its own peril. Cases construed in 69501 state that this is essentially an estoppel argument, that because you didn't record timely, you're stopped when that subsequent creditor or purchaser for value its rights accrue later than yours and you were negligent by not recording timely. Your Honor, I'm almost out of time.
I'd like you to answer one question, but before, counsel, if we were to agree with the appellant's position with regard to the recording outside the chain of title, what would be the implications for title examinations in the state of Florida?
Your Honor, the title, the ramifications for the title industry, in my opinion, are that no search of the public records is a thorough and diligent search unless every single document in the public records was examined, because you've narrowed that scope of that examination now from the chain of title to the entire official records, which it goes back well over 100 years in the counties of Florida and comprises literally millions of documents, even in counties that are of moderate size.
Thank you.
Yeah, Counsel, just my understanding, for those counties who have now computerized searches and where you can search by track, would such a search have revealed the filed or recorded mortgage in this case?
Your Honor, if the search enabled you to search by track, you would effectively be searching the chain of title to that parcel. For the most part, assuming an instrument was recorded during the same time that the person granted that instrument owned that property. But the search systems that I have personal familiarity with are the clerks of court. The search is by name or by book and page number, and not by track number.
Okay. One final question. With regards to the issue of actual or constructive notice of the Bentleys of the filed mortgage, why didn't Mr. Needle's affidavit that the realtor involved was a transactional closing agent for both the Peterson and the Bentleys, and that realtor knew that PMI owed money to the Needles, create a question of fact on the issue of actual or constructive notice?
Your Honor, the Needles affidavit does not raise a genuine issue of fact, because nothing in this affidavit speaks to Mr. Needles' mortgage to Gifford and Haygood. What the Needles affidavit says is that Mr. Peterson told Mrs. Mackin, one of the realtors, which you have hearsay number one, that he knew that he owed money to my company, meaning Peterson owed money to Needles. This affidavit doesn't speak to money that Needles owed to Gifford and Haygood. He goes on in paragraph 5, the next paragraph, money owed to my company in connection with the transaction of the lot to Mr. Peterson or his company. So again, this affidavit on its face doesn't speak to any knowledge the Bentleys have of the appellant's mortgage. This speaks to money that Mr. Peterson owes.
Anyway, there's no dispute that your client signed an affidavit under oath that they didn't have notice of this mortgage, right?
Yes, Your Honor.
And there's no dispute that the only way they could have had notice would be if notice isn't constructive notice imposed by law. That is, whether it's filed late or not outside the chain of title.
That was the argument before the trial court, yes, sir.
I mean, those facts are not in dispute.
No, sir. The facts are not in dispute. There was no evidence, summary judgment evidence, that rebutted or the Bentley's affidavit. What the Needles affidavit does, he goes on to speak of his understanding that a realtor represented the Bentleys, but nothing in this affidavit refutes the Bentleys' express language in their affidavits that unequivocally says that they did not know about this mortgage. So it did, in fact, as Your Honor said, boil down to constructive notice.
Was the realtor a transactional closing agent in this case?
I'm
Was the
sorry.
realtor a transactional closing agent in this case?
Your Honor, there's nothing in the record, and I'm not aware of whether or not Preston Murphy was in fact an agent that represented the Bentleys, other than this Needles affidavit that speaks to his understanding. Importantly here, this motion for summary judgment was filed in June of 2014. The hearing was not for about 6 months later. So Gifford and Haygood, the appellant, had 6 months to depose the Bentleys, to test the veracity of their affidavits. They had 6 months to depose his realtor, find out about his involvement and what information may have been conveyed to the Bentleys, if any, and even if that agent actually even represented the Bentleys. They had 6 months to subpoena the title examination records. They had 6 months to depose the title examiner. They simply didn't do any of that, Your Honor. They were entitled to a reasonable opportunity, discovery. 6 months, I submit, is certainly a reasonable opportunity to do that. No argument was made at the summary judgment hearing, as the transcript of that in the record will reflect, that there was any reason that this motion for summary judgment was premature because they had outstanding discovery or was discovery that they had not had an opportunity to conduct.
Thank you, Counsel.
Thank you.
Counsel, you referenced Mr. Neely's affidavit in your argument. Counsel Appleby's, of course, referenced the Bentley's affidavit. So you have one affidavit here, and you have the other affidavit here. How does Mr. Neely's affidavit create a question of material fact on the issue of actual or implied or constructive notice to the Bentleys that monies were owed on the property at the time they filed their warranty deed?
Two things. One, we rely on Mr. Needle's affidavit as well as Ms. Gifford's affidavit. And the reason why we rely on Ms. Gifford's affidavit is because that sets the picture for when the specific instruments were filed. So based on Ms. Gifford's affidavit, we know that the mortgage from Mr. Needles to Gifford and Haygood was filed and recorded before the warranty deed to the Bentleys. So we rely on Ms. Gifford's affidavit for that proposition, which defeats the Bentleys' assertion that they didn't have notice. Their assertion that they didn't have notice is an argument that they didn't have actual notice. They're not saying we didn't have notice because we examined all the records. It's a conclusory statement at best, which asked us to assume the entire realm of notice in one actual sentence. So we have Ms. Gifford's affidavit, which defeats their claim they didn't have notice. What Mr. Needle's affidavit does, Mr. Needles gave a quitclaim deed to Peterson Managed Investments. Okay, so at that point in time, in the record is a quitclaim deed. Then we've got a mortgage from Needles to Gifford and Haygood. So when Needles gave that quitclaim deed to PMI, he is giving them title to the land with any and all encumbrances that he had imposed on the land, which is the mortgage, which was filed before the Bentleys. What Mr. Needles did was he informed the Bentleys through their agent that there was money owed on the land, which would relate,
and that he had no intention of paying it.
and that there was no intention on satisfying that. So that cuts to the question of constructive notice through Ms. Gifford's affidavit that it was prior recorded, it's a prior recorded mortgage, and then as to actual implied, based on all the evidence, the quitclaim deed, the mortgage, the prior recorded mortgage, and the information that was provided by Mr. Needles to the Bentleys through their closing agent. Now, why I think that's important is the appellees and the trial court relied on the Pearson v. Bill case. It's an old case, 1938. Times are different. Back then, they were flipping pages in books. Now we have computers. But most importantly, the Supreme Court had the opportunity to kick this case on its can right then and there. Because what happened was, in that case, the mortgage that was at issue in that case was eventually filed. But the court made no discussion at all of whether it was filed within chain of title or not. The court was only concerned with what was in the record at the time the last deed was recorded. And that's exactly what we're asking this court to do in this case, is look at what was in the official records at the time the Bentley's warranty deed was recorded.
And what specifically would the purchasers have had to have done to be able to discover this recording? help us understand that. I mean, putting aside whether or not Santa Rosa has electronic records, what diligence would have to be undertaken to discover this late filed mortgage?
The only thing that 695.11 speaks to is the series of numbers. I'm not a title agent. I've never handled a property closing before. But in my opinion, the burden is on them to show that they conducted a search of the record that they were required to, and there was no evidence of this mortgage in there. All we were required to do is show that our mortgage has a lower series number than their warranty deed. And we did that through Ms. Gifford's affidavit. So the burden was not on us to go and say, you should have done X, Y, and Z. The burden is on them to say, we did what we were supposed to do, and we didn't discover the mortgage. And that's not what they've done in this case, because the record is abundantly clear that my client's mortgage has a lower series number in the official records.
But it's also undisputed that your client filed the mortgage late after the quitclaim deed was issued, and there thus would not be in a grantor-grantee chain of title. I mean, it's okay to concede that.
Yeah.
This is a crystallized legal issue.
Yeah, I think it all depends on how you look at chain of title. Are we looking at chain of title as to the person or chain of title as to the property? Because if we look at chain of title as to the person, the mortgage wasn't filed while he owned the property. But I don't think that's what any of these cases are talking about. If you look at every single chain of title case that they've cited, and I agree with Your Honor, this is a novel issue that has not been decided. But if you look at every case that they rely on, every single case, every single one of them, and he kept saying case after case, but every single one of them was asked to the issue of whether the person who was granting the instrument owned the property at the time they granted the instrument. And in every single one of those cases, the grantor did not own the property when they signed the deed. They did not own the property when they encumbered the property through an amended restriction. They did not own the property whenever they executed whatever document. But in this case, Mr. Needles owned the property when he granted the mortgage to my client. And that's the specific inquiry that
But he
the court
didn't
needs
own
to
the
make.
property, maybe I'm wrong on this, he didn't own the property when you recorded, right?
He didn't own it when he
He had
recorded.
quitclaimed it to PMI,
He quitclaimed it to PMI in a quitclaim deed.
and you recorded about a month, your client, about a month later, as I recall, after the quitclaim deed.
It was shortly,
You recorded in November 13, as I recall.
it's sometime in November, yes. Sometime in November, yes. So,
Thank you, counsel.
Thank you very much.
While now pertinent to our disposition of this case, was PMI a BFP in this case?
was PMI a what?
Bona fide purchaser in this case?
I don't think they were. And the reason why is because they had a quitclaim deed for consideration of $10. And I don't think that falls within the purview of a bona fide purchaser.
Thank you.
Thank you.
This concludes our order for this afternoon. We are adjourned.
All rise.